I'll share a presentation that I'll be able to do so in a second. No. Can you see the presentation?
No, it's not visible.
No? Okay. Let me then see. I hope that it works now. Is it visible?
Yes, we can see it now.
Okay, good. Thank you so much. So,
although it's a blank, all right, it's visible now.
It's visible. Oh, okay, great. Thanks. Thank you, Alexander. So I haven't seen you for a while, and I hope that everything goes smooth with other classes. We will have class, as you know, today and on Friday together, and then next week also we will finish with the feminist judgments. Next week on Monday we will have hopefully someone from the European Court of Human Rights to tell you how to draft the decision and what are the important features and how to include gender perspectives. So I really expect that the class will be also very practical for you. And then on a final day next week, we will exercise. We'll have exercise which is related to your exam, and then you will have more information on how it will look like. But today, let's start because we didn't have. It was late, and we still have several presentations to go. You know that we scheduled a discussion on the right to life, and usually when we speak about the right to life, we do not speak about the gender perspective. The usual notion is that the right to life of everyone should be respected, and that there is no gender component in it. So I will start briefly, just with some brief elements of the right to life, which are general, and then we will see on all these assigned topics today how much gender perspective is important also from the perspective of this inherent right. So the right to life is, as you know, the inherent right, which means, and we usually say within the core of human rights, that all human rights are interrelated. In that we cannot say that some are more relevant than others. But what we also know, and why the first notion when we speak about specific rights and freedoms within the corpus itself, we always name and start from the right to life, because we know that this is the precondition for the enjoyment of all other rights. So this is why the right to life is inherent to human dignity, inherent to integrity of a person, and also is a precondition for the enjoyment of all rights. You remember that some of our classes, we said that when we speak about human rights, that we usually start from the obligations that state has in relation to human rights. And we say that this is a threefold, these obligations are threefold: the right to respect, the right to protect, and the right to fulfill. And all these elements are visible when we speak about the right to life. What would be the right to respect? It's, of course, the first and primary value. It means that we need to have laws in which we guarantee the right to life and the use of force. Now we see what's going on in the US with its ICE and with the whole situation of using lethal force, which leads to the death of some people. So the right to respect means to have a legislation which will be in accordance with international standards and which can guarantee the right to life. Obligation to protect is when we have situations when there is the danger to someone's life, that the state and its authorities take everything in their power to refrain, to protect the life and to refrain the lack of force against someone. And the obligation to protect is very much present when we speak about domestic violence. And when we have information, or we knew or ought to know that someone's life is in danger because the situation was reported to the police, to prosecutors on many occasions, and then nothing happened. So it means obligation to protect. In other words, to react. But then we have obligation to fulfill. What does it mean? Obligation to fulfill is basically also extremely important, as usually when we speak about those threefold obligations, we forget about the right to fulfill. The right to fulfill will mean that, first of all public officials dealing with domestic violence cases are trained to recognize the threat, that we have shelters equally distributed over the country in order to allow someone whose life is in danger to get immediate help, and things like that. So it means obligation to fulfill. So this is why it's important to also have this perspective here as well. We have many international documents that guarantee the right to life, starting from the Universal Declaration of Human Rights. And what we see is Article 3 is the shortest one that we have in international legislation, as everyone has the right to life, liberty, and security of the person. What we see is that the right to life is connected with security, which it is. It is interconnected, but in a way, this is not the way of how other international instruments treat the right to life. Usually, it is a separate one, and the rights which are related to security are a part of a specific provision. International Covenant on Civil and Political Rights, Article 6, paragraph 1, says every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. So what we see from this, let's say, it's not a definition, but the way of how the ICCPR is treating the right to life, it first says that it's an inherent right. So for the first time in international order, we have this very specifically, that states need to introduce laws protecting the right, and then that's basically what we are really protecting here, arbitrary deprivation of someone's life. What does it mean? It means that if it's not arbitrarily, that someone can be deprived of his or her life. And you remember for the previous course, when we spoke about the international and European law, from the gender perspective, that we also discussed, and we said that there is a possibility to deprive someone of his or her life when we speak, for example, about international humanitarian law in armed conflicts, in other words. Convention on the Rights of the Child also has a separate one, a separate provision. It says states parties recognize that every child has the inherent right to life and ensure to the maximum extent possible the survival and development of the child. So see, it's a very specific, because it covers people who are under the age of 18. So what we see, this convention again repeats that we are talking about the inherent right, but it says to the maximum extent possible the survival and development of the child. So it's the right to life and development, which is interesting. And then we'll see later on how it relates and how the Committee on the Rights of the Child defines it. The Convention on the Rights of Persons with Disabilities also has a provision. It says state parties reaffirm that every human being has the inherent right to life and shall take all necessary measures to ensure its effective enjoyment by persons with disabilities on an equal basis with others. So what is also very specific in relation to this article, Article 10, is that for the first time we see that someone is in a comparable situation with another person's, or that the right to life is very much connected with the right to equality or the prohibition of discrimination, which is also extremely interesting. And we know the origins of this, taking into account what are the specific challenges that persons with disabilities are facing with. And then we have our CEDAW convention that we discussed previously. Basically, CEDAW Convention do not have a specific provision guaranteeing the right to life. But the right to life is protected from not only Article 6, which prohibits some forms of gender-based violence, but also from general comments, especially number 12, 19, and 35, which deals with gender-based violence, and what leads and where gender-based violence leads can also be the deprivation of someone's life. American Convention on Human Rights is interesting, and this is the one which is the very specific, because no other convention says from which moment we guarantee the right to life. Usually it means when someone was born. From the moment when someone is born, then that person has a right to life. American Convention says every person has the right to have his life respected. This right shall be protected by the law and in general from the moment of conception. No one shall be arbitrarily deprived of his life. So the only element which is included from the Article 6 of the ICCPR is that in general, from the moment of conception, we are guaranteeing the right to life. How it affects? It affects the region with very restrictive policies on abortion, and we will discuss it today. African Charter on Human and People's Rights in Article 4 basically says human beings are inviolable. Every human being shall be entitled to respect for his life and the integrity of his person. No one may be arbitrarily deprived of his rights. What we see, what's the new element here? Integrity. We don't have integrity in other conventions, so they're also respecting integrity. And it's also, the first sentence is interesting. Human beings are inviolable. So it puts a collective approach. And what we also have in African Charter is that everything is in a way structured from the perspective of a collective and individual, but collective is it's much more visible than in other international instruments. And then finally, we come to the European Convention on Human Rights, and very famous Article 2, which says the following. Everyone's right to life shall be protected by law. Everyone's life. So again, individual approach. No one shall be deprived of his life intentionally. So if it's not intentionally, there is an excuse, of course, if other elements are met. In the execution of a sentence of a court following his conviction of a crime for which this penalty is provided by law. What does it mean, basically? What's the rest of this provision says?
National law should actually decide in what way.
Yes, but what does it mean? That Article 2, Paragraph 1 originally allowed death penalty, exactly. So death penalty was, in the time when the convention was adopted, was also, let's say, legitimate way of depriving someone of his or her life. Today, as we have two additional protocols which were adopted additionally to the European Convention, one is Protocol 6 and the second one is Protocol 13, death penalty is prohibited in Council of Europe member states. And today, basically, we have only this first provision that everyone's right to life shall be protected by law. And then we have this second paragraph of Article 2, which says, deprivation of life shall not be regarded as inflicted in contravention of this article when it results from the use of force which is no more than absolutely necessary in defense of any person from unlawful violence, in order to effect a lawful arrest or to prevent the escape of a person lawfully detained, in action lawfully taken for the purpose of killing, a riot, or insurrection. So it means that, again, from all these provisions, Article 2 is specific, because in paragraph 2, it also gives us three situations when the state can deprive someone of life, and when that deprivation will not be arbitrary, at least from the perspective of the purpose, because we have exactly enlisted situations when it can be done. What is important, I put a lot of, I gave you also here in this presentation that will be available some cases. So if you want to read more in general on the right to life, about specific situations in which the European Court of Human Rights dealt concerning the right to life, the only thing that I want to tell you is Protection from Non-State Actors Act that I already explained, and this is the situation of domestic violence. So state is usually responsible for the acts of its own state officials, whether it is a legislator, whether it's executive or the judiciary. State is responsible, and usually in terms, when I speak about the right to life, it comes from the executive, from the police officers, from those who are in a way protecting the legal order. However, the state can also be responsible for private actors, and this is very important to understand that it is very much present when we speak about the right to life. It's not connected with other rights and freedoms guaranteed in international documents. And this is the situation when, and this is the standard that I already said, when the state knew or to know that someone's life is in danger, and the state didn't do anything or did very little, not enough, to protect someone's life. It can be situations of course, domestic violence, which is important for our topic, or any other kind of gender-based violence, for example, human trafficking can also has elements, but it can also be when someone is put in detention, when we have people deprived of liberty. And please take into account the deprivation of liberty is a very broad notion. If the deprivation of liberty exists, even for those who are in psychiatric institutions, even for those who are in asylum centers and migration centers, and especially when they are not allowed to leave at any point, when we have very strict working hours, there are police officers who are there, so the person cannot leave that compound easily. It can also be the case with people who are in some, let's say, social institutions, for all elderly, for people with disabilities. So this is why we have the whole movement of deinstitutionalization and having alternatives to allow everyone, even those who are not, who did not commit any crime and who are not deprived of liberty due to that fact, to be much more proactive in the community and not to be placed in institutions where we can consider that they are also deprived of liberty. So this is important because in some of these compounds we have dominantly women. What we know also, for example, that women with disabilities, and we now again refer to the previous instrument, this Convention on the Rights of People with Disabilities. Why it is also relevant, because we know that sterilization, forced sterilization, is a very widespread practice which exists in many countries in those institutions. So sometimes sterilization, if it's not done correctly or not, in a way that it can endanger someone's life, can also lead to the deprivation of life, and it can also have a very significant gender component as well. For euthanasia, because when we speak about the right to life, we usually speak about two institutes. One is apart from the right to life itself, about euthanasia and about the abortion. So as abortion has a gender component, we will speak about abortion, but not about euthanasia. The only thing that I want to now say is that when we speak about this institute, there is no common ground in international legal order whether the state should allow euthanasia and under what conditions. So this is why we have a very unequal practice of different states. And in one very emotional case that was decided by the European Court of Human Rights, Frankie versus the United Kingdom, we had the applicant, a woman in her 60s. She was dying from some regenerative process, which led to her death, and she was suffering from pain, and the whole her life was miserable. And what she wanted is that the authorities of the UK that they in a way guarantee, because she really needed suicide suicide which was assisted, and she couldn't commit suicide without the help of her husband. And she said, I really want a guarantee that you will not criminally treat him because it's a criminal act. And the UK government said, but we can't, we understand in what position you are, we understand the suffering, but we criminalize euthanasia, so we cannot help you with that. So she submitted the complaint to the European Court, and then she also presented her case. She came to Strasbourg, and she really wanted that judges see that she's suffering in a wheelchair. And the judges at the end, when they decided the case, they said that they have a sympathy towards her, but the right to life do not guarantee the right to end the life, and that they cannot say that it is a part or a component of Article 2 of the European Convention of Human Rights. For the use of lethal force by state agents, this is interesting because now we see that it's very, at the moment, it is important, and these are the standards that do not relate only to the European Court of Human Rights, but they are also part of ICCPR, this International Covenant on Civil and Political Rights. And when the state authorities are using the lethal force, they really need, we have to have this standard, which is very, very high, which means beyond reasonable doubt. We really need to know that it was absolutely necessary to use the force. And how we know that? We know from all the facts of the case. I don't know if you followed what happened in Minnesota, but for example, the government was saying one thing, the governor of Minnesota said another thing, and now we have videos which are shared in different social media showing that basically what the government said when this person died and he was killed, that it's not accurate. And then now we have some users of social media saying that it's also generated AI. So we really live in a reality when it's easier from one point, but also at the same time harder to collect all the evidence and to have proof beyond reasonable doubt. I already said that the right to fulfill means that not only that the state needs to adopt laws which are in accordance with international standards. So what, for example, force can be used, under what conditions, what needs to be double-checked in order to in a way, examine the situation and to know if there is a need to use the force. Because you remember that now the whole issue was whether this person had a gun. And whether some police officers saw that he will use that gun and that he will kill some of these officers. There is doubt and dispute about it, but it has to be very clear. And of course, as I said, training needs to be a very significant part before any operation is taken on the ground. And it means also that planning and control of the operation needs to be in accordance with all these standards, with the aim to, at the greatest possible extent, minimize losses, not injuries, but of course the loss of life. And a very important component is procedural one when we speak about the right to life. What does it mean? It means that when we have a case like this one, then a thorough investigation needs to be undertaken. And there are clear standards which states need to follow in order to, again, to act in accordance with international standards. First of all is independence. So who is conducting that examination? It cannot be the same body whose official committed or deprived some life. And this is what we usually have. That we have like this is usually the police, and then we have some special department of the police who is undertaking the examination and investigation. It's not allowed in accordance with international standards. There has to be strict independence of a body who is acquiring the situation. I think this means that the way of how it is done also needs to be in accordance with international standards. It has to be a thorough examination. it means adequate examination. I can say that I established a commission and I'm doing something, but there is no proof that I really conducted any research of the situation. And a part of adequacy, but we put it as a separate one because it's usually the one who is misleaded or is not respected in many situations, is promptness and reasonable expedition. It means that it has to be timely. If it's not timely, then we are using facts and evidence on the ground. Public scrutiny means that public needs to be informed of each investigation regularly. Not I'm coming, I will address you, and not in a way to give only very basic information, but really to give a very thorough information on what I did, what I conducted, and what are the preliminary results. And the participation of the next of kin means that, which is also happening in many situations, that those who are like close relatives and friends are not informed of the results of the investigation. And adequate sanctions, it means that the whole purpose of investigation is to identify who did what, who is responsible, and then to issue sanctions, because this is a very important part of prevention as well. And redress, of course, for those whose dear ones lost their lives. Why gender perspective? And this is what we will see from your presentations, that different sexes, they have different risks. For male, we have, for example, use of lethal force in some operations is more related to men than to women. So there are different risks. Patterns of state commission, it means whether the state takes seriously some crimes, and we will see for some of your presentations, is it the case or not? And systemic invisibility of certain forms of killing, which means that sometimes we don't see that they are problematic, or we just don't think that they should be separate from other forms of loss of life. And when we speak about gender patterns of lethal force or lethal harm, femicide and intimate partner killings are very specific, very gender related. Honor killings, the related deaths, mortality due to unsafe abortions or inadequate healthcare because of different restrictions which are related to abortion. But also, we apart from abortion, what can also lead, and why I put inadequate healthcare, it means that also obstetric violence can lead to the death. Trafficking and sexual exploitation, which is again very specific for women and girls, and gender-based killings in conflict and post-conflict settings. And this is what we see now, for example, in Sudan, but also in many other countries, some of them also very visible in Palestine as well. I will stop here and just say that failures in procedures, which are extremely relevant, as sometimes that we have victim blaming. It's also very, very much present in many contexts. For example, when we have especially domestic violence and then femicide, you should just see and read the comments of people posting on social media their interpretation of the case. So victim blaming is something that is very, very much present in many countries. Trivialization of violence. Sometimes it's really, we have actors saying that it's trivial to discuss and to take this perspective into account. Failure to consider patterns of abuse, it's very important because in some countries it really leads to inaction of state actors, even when we have a very clear pattern that the risk. The usual answer that state authorities have if they react, I mean, if they did not prevent someone from killing, they will say, but we didn't recognize. The person reported, yeah, but we thought it's a quarrel between two partners. So this is the failure to consider these patterns very, very seriously, and also treating, especially femicide, as isolated incidents. And this is what happened in Serbia a few months ago, when we had a minister claiming that we have decline in a number of femicide cases. So this is exactly, you are not showing that systemic pattern that exists in a society. With that, I'll call first a person who had femicide, because I think it's very much relates. First of all, does anyone have a question? Everything was clear? Okay, great. Una, the floor is yours.
I think I will need help with
Yes, I hold it.
I'm not to the toilet, but
Of course, of course. You say it's not easy, but you can't move, so you can't. You have to be here. I know, but I'm telling you, it's because it's for me. It's very unnatural of sitting, but yeah, we'll first of all close this one. Website, great. Then online folks, can you just confirm that you can see the presentation?
We can see it.
Okay, great. Okay. What I do is your grades, yeah? Yes. I'll be here and be you. If you have any questions, if anything's not clear. So how I just of course, we have to start with the definition of femicide and why is it important to name such acts. And of course, then it's related to how it falls into the scope of right to life. Femicide or feminicide, if I'm pronouncing it right, it's referred in that way in some international instruments or some books and other papers about femicide, is defined also in many articles in many international instruments as an intentional killing with a gender-related motivation. Also, we have Femicide, The Politics of Killing Women. It's a book that I will refer to many times in this presentation. It's by Daniel Russell and Radford, and they at the beginning defined femicide as the misogynist killing of women by men. And of course, we have this debate, even here, but also in public, of why is it important to differ the femicide from homicide. Some say it's homicide is homicide, and it's murder is a murder, and there is no much difference. So in homicide, we are talking about very gender-neutral act. And the motivation may vary, as we know from our criminal codes. It can be various of motivation. But for femicide, we have to keep in mind that it's always gender-related motivation, and it is rooted in discrimination, patriarchy, and the patriarchal system in the society, and of course in equal power relations. That means also we can see from various practice financial power and control over the victim. So financial control, but also physical or psychological control of the victim/survivor, as they like to highlight in the various instruments. Gender stereotypes and harmful norms, of course, and it's also important that is the most extreme manifestation of violence against women, and it occurs along a continuum of violence. So it's patterns of violence that it's very that lasts long, that it's very have the beginning and continuous of in time, and it's not an isolated act. And of course, it's related to other forms of gender-based violence, such as domestic violence, sexual violence, harassment, human trafficking, etc. So we always had acts of femicide before even the term existed, and again, in the book Femicide, The Politics of Killing Women, they in the beginning say the femicide is as old as patriarchy itself. We have the killing of female children in antique Greece, where the feminine child was taken into account as an ill child, as a child with disabilities. Of course, we know about witch hunts or examples from noble families in which women were killed by their husbands because of destabilizing in the family, in the patriarchal society. And of course, the story of Mirabal sisters. They were from Dominican Republic in the 50s, and they openly opposed the system and dictatorship as well. And they were killed on November 25, and November 25 is now International Day of Elimination of Violence Against Women. So the femicide lasts long before the term was invented. Yes, and I have a lot of pictures to just not be text, and it's a memorial of femicide, of course, from artists from Mexico, which is very related to acts of femicide, and we will talk about it later. Of course, naming matters, and it is firstly named in the book that I mentioned, but also the French dictionary include the term feminicide in 2015, of course, defining it as the killing of a woman or a girl because of her sex. And yes, sex is problematic, but then the Oxford Online Dictionary, for example, defines it as the killing of a woman or a girl, especially by a man, and on account of her gender. And of course, after the very extreme situation in Mexico and in Ciudad Juarez, where 1,500 women have disappeared since 1993. Then the femicide was very localized, and after the findings about what really happened, femicide in Mexican legislation as the killing of a woman because she is a woman. And then there you can see the picture of a memorial in Juarez and 16 crosses that represent victims. And they're all over Ciudad Juarez, and where they found a massive places that women were killed, they put the crosses all over the city. And now we have the international legal framework. We mentioned already the Universal Conventions, the Universal Charter, the Covenant on the International Covenant of Political Economic Rights, and the European Convention on Human Rights. But I wanted to share just where the femicide as a term or killing of women were specifically mentioned. So we have UN General Assembly resolutions. We have several of them, and these UN General Assembly resolutions, as we know, are non-binding, but they articulate international standards. They present political commitments, and that's why they're important. And they are important because they really do say femicide and why. What should states do in addressing violence against women? Next we have a CEDAW. CEDAW is elimination of discrimination of all women, but it doesn't, as we said, speak about right to live or femicide. But we have
recommendation number 19 that does say that gender-based violence is discrimination, and it speaks on about gender-based violence and state responsibilities and the state responsibilities for private acts. It's not just what the states do, but also that the state is responsible for what happens in within walls of private homes. And of course, they highlighted the due diligence application, protection, prosecution, training, and removal of honor defenses. But Dushanka will say more about honor killings. And we have recommendation number 35. It's kind of an update on the recommendation number 19. And they really also put into the term femicide, and they spoke about gender-based killing of women. And they highlighted the importance of data, that data should include complaints, protection orders, prosecution, and conviction rate, sentences, reparation, and case duration, but also type of violence, victim relationship of the victim and the perpetrator, age, and so on. Of course, and the goal was from this recommendation is to strengthen prevention, protection, prosecution, punishment, and redress to eliminate femicide and other gender-based violence. And of course, they mentioned that it's of course so growing again, and it's not stopping, and the numbers are higher and higher every day. We have also the Istanbul Convention that doesn't use, of course, the term femicide. It addresses the killing of women through provisions of physical violence, mandatory criminal prosecution, and so on. But we can see, you can see the relevant articles for this topic, but they have the monitoring body that is important that we can see through the work of Grevio, how do they address the femicide as problem. So I, of course, took Serbia as an example. I'm trying to think of that word for now 5 minutes. So they have several papers about Serbia, but the last one is building trust by delivering support, protection, and justice, and it is thematic evaluation report, and they have a whole part about gender-related killing, and the importance again of data and the problems within our criminal code that allows the prosecution of femicides to be not always the same, to differ, and to not show really what is the problem, and to provide judicial insecurity for the victims, but also for the society. So, and of course, they stress out the characteristics of the perpetrator for when defining sanctions, that in some cases gender stereotypes are used in judicial reasoning, and therefore shifting responsibility onto the victim blaming, and secondary victimization that occurs as a problem. Of course, they stress also the systematic failures from the police and from other social institutions that have to be connected. And the data, they show that the 20% of women killed between 21 and 23 had previously reported violence. And of course, they again stress the no available data, and the data is provided by NGOs. They also stress the problem of attacking and shrinking safe space of the women NGOs that are providing the statistics. And we had, I think last month, the situation in Leskovac, where the president of Women's Peace Organization. Her home was ransacked and nothing was stolen, only because she spoke loudly about femicide that happened in Leskovac. So this is a little bit of how Serbia is doing. This is a picture of various protests about also stopping femicide, but putting femicide into criminal code in Novi Sad. And now what is most important to know is that we can proceed femicide in intimate partner violence, sexual violence, harmful practices, and hate crimes, armed conflict, of course, trafficking and organized crime, but also nowadays, although femicide happened a lot of years ago, today also we have another big problem is technology. 3 out of 4 victims were previously stalked. Stalking happens also on the internet via social media, and online, of course, presence can trigger escalation. And we can see key takeaways from the international framework, but also that femicide is often predictable and preventable if early warning signs and digital risk are recognized and addressed. And I highlighted the sentence from a Canadian author: men are afraid that women will laugh at them, women are afraid that men will kill them.
Is there any questions or comments to what we've heard? Anything that maybe you wanted to share from your jurisdiction, if you're not from Serbia, or in any way, if you took part in some activities, if you are aware, and if you ever been to some conferences, roundtables, when the whole issue was discussed, if anyone wants to maybe come, or maybe if we have someone from our surrounding that was in a situation, hearing or online, and we would like to dedicate as a topic. No? Everything was clear. Do you think that it's really important that we have a separate code on femicide?
Yes, I think yes.
Why? What would be the reason for that? Because you have two let's say, two sides. There are one who say that criminal code is already very well defined, so that there is no reason that we cannot use what we already have to strictly prosecute or so this is one. A point, another one is that we really need to have additional criminal act which recognizes femicide. So my question for you would be that there needs to be a specific act. What's the reason for that?
And I think that intent is important in all kinds of murders, and that's femicide as well, because then we can understand the criminal act and we can, I think, get into the scope of what is really the problem and then work on prevention, not just the prosecution.
Next question, would it be the same penalty as or higher?
I think higher, because you have also the teže okolnosti. Yeah, that you have to put in account. And I think for me, if it's power related and if it's gender related, and you have all those characteristics, then it had to be a higher sentence.
It is weird your position because the gender-based violence exists because it should exist in prisons. Why are we opposing it for femicide? That's sort of gender-based violence. It's gender-based force. So that cannot be only homicide because if you have a gender-based violence, a type of gender-based violence is.
The problem lies in several factors. First of all, if you have femicide, sometimes then you really need to prove beyond reasonable doubt, because in a criminal procedure, let's say the the standard of proof is higher than in civil procedure, then you have to prove beyond reasonable doubt that the reason was that you killed someone because that specific person is a woman. And sometimes it's not so visible from the fact of the case. You know, you have got a feeling, but there is nothing that this person said, for example, before the person was killed, or, there are different, this is the issue. How we distinguish between, if we have a partner who's violent, or we have ex-partners or partners, and then someone, a person is killed, it's very likely that the reason is femicide. But in some cases, it's not so clear. And if you have only one act, then it will be easier because you'll just see the elements, not the intention to kill someone just because the person is a woman. That's one reason. Another reason is that there are also some other groups claiming that that they should be also recognized. It's not only femicide. And they have hate crime. So it means that either people who are LGBTIQ+, they should be recognized specifically. We also have the disclaiming this. So then you're just asking why you make a difference between specific minority groups. That can be the purpose of killing. So this is why it's a debate. And also another issue is that in some countries, especially in the regions which introduced a new criminal act, they claim that it did not stop or prevent the act itself, so that we need to more focus on prevention and on all these harmful practices and stereotypes and patriarchy that Una mentioned, which is, of course, something that is absolutely must. But at the same time, it's good to recognize, because in a way, having a specific criminal act will also show the zero tolerance, which is extremely relevant for many countries in the region. Bulgaria, Romania, even Poland, where we had Hungary, when we had cases of domestic violence, which led to femicide, where the state was not doing everything it could in order to prevent and also to react adequately.
I think it's also possible that if it will be in the criminal code, that it's not going to be used, because for example, we have the criminal crime, but the practice for criminal crime is hate crime. Is very, we have no practice of it.
And Una mentioned aggregated circumstances. I'll try to get also the back. I'm not sure if I succeed for the Friday, for the part class, to also at least give you an example of Serbian, because her organization, they collected many cases decided by the court, so they see the pattern of how drivers and prosecutors treat cases of homicide. And it's interesting to see some of these points, but the one that she took to rewrite for one project that we're working together, it's very interesting because you really see what the court took into account and whether the court relied and used very circumstances to issue the sentence. What do you think? Yes or no? Well, I mean, what's your sense?
I think
No? Yeah. But I
but also, what do they take as abbreviated matter? Is it a family man? For them, it's a good thing, but it's even worse thing than if someone is a family man, an officer, an army guy, or something like that.
Probably usually they use as one of the factors to basically issue a less harsh sentence, the behavior of it. If she provoked. And that's why I'm saying, if you're civilizing violence, then you can have the perfect law, but the implementation of the law will be extremely weak. And this is why many countries are still facing that side. Una, ask folks who are online if they have any questions.
If you have any questions or comments, feelings.
No?
I don't think so.
No one? Okay, do you want to continue or you need 10 minutes break?
I would be fine with a break.
Break? I knew it. Okay. 10 minutes break, okay?
All right, see you in 10 minutes.
Okay. Well, I know it's harder to follow online, and I know that after some point, you remember last time, I don't know, I forgot about the break. It was almost a riot. Oh, not parents. Yeah, okay. No, you can be. Yeah, no, please. I mean, there is no specific order, so I think you're going. Everything is connected. Yeah. Okay.
কেমন আছেন? এরা কে ভাই? এরা কে? হাজবেন্ড ওয়াইফ? এগুলো 45-এর বেশি বয়স, এগুলো রানে লাভ নেই। মহিলা এগুলো কোনোভাবে চলবে না। মহিলা দরকার আছে, বাট বয়স হয়তো 30-এর করে। মহিলার রিকোয়ারমেন্ট আছে, মহিলা লাগে। ওই রান্না বান্না করে এটা সেটা হাবি দরকার আছে। পুরুষগুলো মানে মানে 45 বছর বয়স হয়েছে মানে কি এর কামের লোক না, আকাম না। এরা যুবক লোক পছন্দ করে। তারপর আপনি ইন্টারভিউ নেওয়াইয়েন নেক্সট রোববার। বস কি বলে দেখি। এটা আমার বলার তো ব্যাপার না, বয়স তো ম্যাটার না। অনেকের আছে বয়স বেশি হলে শরীরে স্ট্রেংথ থাকে, অনেকের বয়স কম শরীরে স্ট্রেংথ নাই। এখন এটা প্র্যাকটিক্যালি কথা বলে বুঝতে হইব। যেমন আমার বয়স কিন্তু 47, আমি কিন্তু কাজ করতেছি, প্রবলেম নাই। সবার তো স্ট্রেংথ সমান না, বুঝেন নাই? তবে চেহারা থেকে এটা বুঝলাম, ছবি দেখে এরা সবগুলো অকেজ হয়ে গেছে অলরেডি। পরে আপনি রবিবারে ইন্টারভিউ করেন, দেখা যাক। ঠিক আছে, কেমন আছেন? কেমন ওই টাকার ব্যাপারে কিছু জানালেন না? টাকা কি দিতে পারবেন কি পারবেন না বললেন না যে কিছু। ঠিক আছে, জানাইন তাহলে। ঠিক আছে, ওকে, ঠিক আছে। বললো আব্বার সাথে কথা বলছি আমি, ভাড়া 35 বললো, আবার বললো ভাড়া 35, 15 তলায় বলে। তুমি দেখো কথা বলো, কেন সব মিলে কেন পড়বে? আগে ক্যালকুলেশন করো কত পড়ে, তারপর জানাও আমারে, ঠিক আছে? যাক, সেটাও তাদের ব্যাপার। এত বোঝার তো দরকার নাই, তোমার যা বলি তুমি শোনো। সেটা হলো, আমি যা বলি সেটা শোনো। সেটা হলো যে তুমি বাসা ভাড়া টোটাল কত পড়বে মাসে, এটা হিসাব করে বাইর করো আগে। বাসা ভাড়া কত, গ্যাস কত, কারেন্ট কত, হ্যাঁ হিসাব করে বাইর করো। গ্যারেজ তো আমাদের লাগবে না, গ্যারেজ তো আমরা নেবো না। নিয়ে ভাড়া দেওয়া লাগবে আর কি, বুঝছি, ঠিক আছে। ঠিক আছে, কথা বলবো, আমি কথা বলতেছি খড়িগুলো। ক্লাস করি। রান্না হয়ে গেছে নাকি?
Okay, folks, I'll put a presentation and please let me know if you can see it. Can anyone confirm?
We can see it.
Great, thank you. Dushanka, the floor is yours.
Ready for questions.
I'm gonna. Okay. So my topic was honor killings, and to be honest, it wasn't the easiest one. It really.
It is hard to be me.
Yeah. No, I understand. And the chair is really low.
I know.
But yeah, this topic really wasn't that the easiest one. It really showed how patriarchy interfered and eventually stopped many lives of many women and girls. And at the beginning, I would love to center where the honor killings actually stand. So honor killings are actually a form of honor-based violence, and honor-based violence stands below of the umbrella of gender-based violence. So it is a form of gender-based violence, and that therefore it is a gender-based violence. So honor-based violence is a form of gender-based violence and can be defined as any form of violence or abuse that is conducted to protect the honor of family or community. I'm sorry, and I have a bombona. The honor-based violence includes the violence committed to restore family or community honor, and most likely it is linked to women's perceived sexual or social transgressions, but not entirely, and it occurs within families and communities, and it is not isolated act. It is really important here to mention that honor-based violence and honor killings are not violence in passion. This violence occurs thoroughly planned, it is strategized, and it is planned within the family. And most of the times, if not entirely, the perpetrators are actually the male side of the family, either husbands, fathers, brothers, or further relatives that are men or male. So honor-based killing, as I said, is a form of honor-based violence, but there are many other forms, such as forced abortion, genital mutilation, stalking, forced marriage to their rapist, if the rape occurred, threats of killing, virginity testing, punishment, domestic abuse. And the most extreme one is actually this bold one, honor-based killing. And honor-based killing is considered a violent crime committed by one or more perpetrator, usually a male family member, against a woman who committed alleged misbehavior or act that brought shame to the family, which the crime is supposed to erase, restoring honor to their family. So I said that I'm going to ask you some questions. And the one that I decided, because I know that there is not enough time, is there, do you think that after doing the honor-based violence, after committing honor-based killing, that the family actually brings their honor back to their family? Does the honor is being restored by killing the one who brought the shame on it?
I don't know who decided.
That is true. Nothing actually happens. They are not giving praise or giving a prize of that doing. The families that decide to pursue the honor-based killing are actually being they don't have a right actually to grieve the descendant, the person who died, because they took the right to use their life, to kill that person. So therefore, they don't have a possibility or right to grieve that person's life. And also, the society is seeing them also in that light. So they don't have actually they're not supporting that. They would be again outcast in the families, and they will not restore that honor. So when I was looking about and researching about honor killings, I asked myself, where did the honor killings occur? Do you know about this movie?
Yes.
You know.
And my generation knows.
Yeah, this is the Lepota Poroka or Beauty of Vice, as the Google Translate translated it. It is a movie from 1986 by Živko Nikolić. He was the director and he wrote a screenplay. And I watched this movie when I was pretty young on television. So it's not an alternative one. It is not something that is, from the background. And I would say that it was quite popular. I don't know now. But this movie is about a couple. They lived in a village in Montenegro where there was customary for a husband to kill an unfaithful wife with a mullet over a loaf of bread. No, laput is for older people, but this is also some sort of actually honor killing. So this couple goes looking for a job in a urban area, whatever, and a wife joins. She started cleaning a nudist resort, and she kind of got amused by life, and eventually she commits adultery. And Mira Furlan, she actually plays the role of Jaglinka. She suffers consequences of adultery. So we watched honor killing on our television on the movie that is pretty much popular back then, maybe not now, but still it really shows that honor-based killings and honor-based violence is not centered in one region, religion, tradition. It is everywhere. And it was really interesting because this showed it sparked the debate whether this is a real tradition or it was made just due to movie and stuff like that. But the director himself said that there was 25 ways of punishing a woman without, for whatever reason she needed to be punished for. So it was really interesting for me to show this. Still, many people from that take some places and in the previous government don't think that the honor-based killings are spread everywhere. For example, Chechen president said that honor killings were perpetrated on those who deserve to die. One lawyer who worked from Supreme Court of Norway said that there should be punishment reduced from 17 years in prison to 15 years in the case of honor killings that took place in Norway, because Norwegian public is self-righteous and cannot understand different cultures. This was in 2008, Pakistani politician defended the honor killings of 5 women belonging to the Umrani tribe by a relative, saying that these are centuries-old traditions and I will continue to defend them. Only those who indulge in immoral acts should be afraid. Yeah. Then we have some disturbing statistics, and this really shows that honor killings are not cultural exceptions. In 2012, there is WHO estimate there was 5,000 honor killings annually worldwide. Last year, this was from the data released by UN Office on Drugs and Crime and UN Women, that there was 50,000 women and girls killed by intimate partners. That means that on one woman or girl was killed every 10 minutes. 1% of these killings are honor crimes, no doubt. There is not enough evidence, but that is due to underreporting. Many of these crimes happen by forced suicide, by giving girls and women poison to kill themselves, or giving them, giving them motivation to do so. In England and Wales last year, 300 honor-based abuse offenses were recorded, which demonstrate that honor-based violence is not confined to non-Western states. And although there is a high prevalence reported in Pakistan, Afghanistan, Iran, Jordan, Egypt, Yemen, this type of violence occurs worldwide, and it's not confined to any religion or region, and it is reported everywhere. Am I going too fast? I'm going to choke myself. So
Who are the victims? The victims are predominantly women and girls, but also LGBT people. So everywhere who opposes the so-called honor of other patriarchs or other males who are seen as a head of the family. Many victims are minor, and perpetrators are usually close relatives, fathers, husbands, brothers. What is interesting, or maybe not interesting but disturbing, is that almost all partners are male family members, but where is possible, the family will decide to choose perpetrator who are under the age of 18. And this is akin to young male syndrome, in which competition for honor, status, and marriage prospect in most intense. This allows the perpetrator to serve the shortest possible imprisonment as a juvenile offender. So where there is a young minor younger male child, he is being motivated to actually do the killing, and then the sentences will be much lesser. But then there is a question: how can we then have the accountability of these crimes if we have a minor who cannot be prosecuted as a fully developed adult man who actually motivated this young person to do so? So that also goes hand in hand with underreporting and the key challenges of honor crimes and honor killings. Legal aspects from national context. In Egypt, so now let's first say that these types of crimes are treated with lesser extent, and sometimes the perpetrator is exempted from punishment. For example, in Egypt, penal code states that the perpetrator is liable to prison sentence instead of capital punishment. In Jordan, the perpetrator may benefit from a mitigation excuse, which means that the act of killing in the name of protecting the family's honor is justifiable and punished to a lesser extent. Iraq, the perpetrator is only punished with prison for a period not exceeding 3 years. In Iran, by penal code, a father or paternal grandfather killing his daughter without any retaliation from the judicial system. In addition, Article 630 allows a man to kill his wife if he witnesses adultery. This is current law. And in countries, but killings are forbidden by law. But these types of killings are seen, in a better lens. And in the countries where honor crimes are considered illegal, lawyers often use the defense in the name of honor, in which a woman is considered the property of man, and the act of killing is self-defense. Other lawyers may use the defense of temporary insanity to exact the punishment they may face if ever caught. So it is really disturbing because the system encourages to use this as a tool for lessening your extent. So we talked about all this, but I didn't know that we would, so I put it. Why honor killings are a human rights issue? Well, honor killings are inherently killings, and they present a breach of right to life, freedom for torture, and inhuman treatment, and prohibition of discrimination, because this is a gender-based violence. These are the articles that cover this one, but I would like to mention from the aspect of freedom from torture and inhuman treatment that there is, now we are going into the instruments, that there is a joint general recommendation number 31 of the Committee on the Elimination of Discrimination Against Women, and general comment number 18 of the Committee on the Rights of the Child on Harmful Practices from 2019 that forbids female genital mutilation, child and forced marriage, crimes in the name of the so-called honor. Sources of international law related to honor crimes and killings. We kind of covered this all, so I'm not going to read it, but you should take into account this article if you are interested in it. I don't know.
You just mentioned Article 15?
Yes, Article 15. Yes, regarding the Article 15, this is the equality in front of the law. So when it comes in, this means that everyone should be equal and have the equal sentences. And because the honor crimes dismantle that idea, this is the article that prohibits that. But regarding the more specific one, we talked about the general recommendation number 19, and Una also covered it. That states the traditional attitudes by which women are regarded as subordinate to men or as having stereotyped roles perpetrate widespread practices involving violence or coercion, such as family violence and abuse, forced marriage, direct deaths, acid attacks, and female circumcision. Such prejudices and practices may justify gender-based violence as a form of protection or control of women. Specifically with regard to honor, crimes, and killings, see the recommendation. General recommendation number 19 states that measures necessary to overcome family violence include legislation to remove the defense of honor in regard to the assault or murder of a female family member. The general recommendation number 35 also adds on to it with discriminatory evidentiary rules and procedures, including procedures allowing for women's deprivation of liberty to protect them from violence, practices focused on virginity, and legal defenses or mitigating factors based on culture, religion, or male privilege, such as the so-called defense of honor, traditional apologies, pardons from victims, survivors, families, or the subsequent marriage of the victim, survivor of sexual assault to the predator, procedures that result in the harsh penalties, including stoning, lashing, and death beating, often reserved to women, as well as judicial practices that disregard history of gender-based violence to the determination of women defendants that states should actually adopt. There are many documents covering the honor crimes. I don't know if I should go through it, but you should know that the honor crimes were a part of the Human Rights Committee's for General Comment number 28, also United Nations General Assembly through various resolutions from 2001, 2003, 2005, stating working towards the elimination of crimes against women committed in the name of honor. I don't know if I should go through what they are stating, but in general, they are calling upon the member states to intensify legislative, educational, social, and other efforts to prevent and eliminate honor-based violence, establish, strengthen, and facilitate support services such as appropriate protection, safe shelters, counseling, legal aid, and etc., to investigate promptly and thoroughly, prosecute effectively, and document honor crimes and punishments. This is also a declaration on the elimination of violence against women. States that member states should adopt all appropriate measures, especially in the field of education, to modify the social and cultural patterns condemned to men and women, and to eliminate prejudices, customary practices, and all other practices based on idea of the inferiority or superiority of either both sexes, and on stereotyped roles for men and women.
Just referring to Zach's
Yes.
report, what is also very specific, usually when we see the excuse of certain practice is invocation of religion or custom and tradition. And this is why this declaration, which is a non-binding document, part of the soft law, has this Article 4 which says states should condemn violence against women and should not invoke any custom, tradition, or religious consideration to avoid their obligations with respect to elimination. It was very important to include that in the declaration, but it's committed in the CEDAW Convention. Of course, if we have general recommendations, but it would be also great if we had the text in the convention itself saying exactly the same. There are, if you remember, this Article 5, like state has to break stereotypes and prejudices, but it's not the same. When you have this provision that the state cannot invoke today, in when we speak about the general landscape in the international arena, Afghanistan and Iran are those countries among which this tradition and religion is most invoked to compel all the rights of women and girls, which is an extreme situation. But we just see where it can lead.
Yeah. Regarding that, we actually have the UNESCO Universal Declaration on Cultural Diversity from 2001 that with Article 4 states that no one may invoke cultural diversity to infringe upon human rights guaranteed by international law, nor to limit their scope. So it forbids the usage of culture or religion or communitarian types of living. Council of Europe also has various documents and instruments that tackle the issue of honor crimes. Some of them are Parliamentary Assembly resolution from 2003, as well as from 2009, with the recommendation in hand, and the final one from 2021, the resolution 2395. These resolutions, the first three are, in general, they are they are calling upon the states to enforce law to punish all honor crimes and treat complaints seriously, to exclude honor as a mitigation factor in criminal proceedings, to implement legislation specifically addressing honor crimes, to engage religious leaders to facilitate cooperation, to establish helplines and statistical databases. The last one, and many more. The last resolution from 2021 calls on the state to remove honor-based justification or mitigation circumstances from criminal code, define honor-based violence clearly in the law and treat it as an aggravating circumstance, and criminalize public incitement to violence in the name of honor. Also to include LGBTI people in the prevention plan and to recognize their vulnerability to honor crimes. So that is something that makes a distinction between other three. Regarding the Istanbul Convention, this convention has specific articles that recognize honor as a honor crime specifically. I'm talking here about Articles 12 and 42, where the convention requires states parties to ensure that culture, custom, religion, tradition, and honor are not considered as justification of acts of violence against women, including claims that the victim has transgressed cultural, religious, social, or traditional norms or cultures or customs, of appropriate behavior. European Union, this is only one that I took, but there are more for sure. This is one from 2011, and it urges the states to reject any reference to cultural, traditional, or religious practices as mitigating factor in cases of violence against women, including so-called crimes of honor. Now, I know that we should prepare the case law, but when I was researching the case law, actually honor crimes are seen as a possibility for seeking asylum. And I didn't want to go through with it because the asylum and refugee law is scheduled for the next class, and I didn't want to go through with it. But also there is a case law, a case with Opus and Turkey that we all read, and I didn't want to go through with it. But there is one, I have actually two. One is brought before the CEDAW committee. This is the case from Georgia, and one that happened in Sweden, and it stayed in Sweden area. Yeah. And they based on this, the Swedish case, they reopened the case for one other killing. So it kind of motivated this. So I don't know if we want to go through with this case and we can discuss, but there are for sure many cases on honor-based killing and honor-based crimes, and they are used for, I don't want to say leveraging, but they are used as a circumstance why some person can seek the asylum. But yeah, so tell me.
Well, should we go? I mean, can you just briefly say maybe there is no need, but if you want to reflect on the case, maybe to just what was
Yeah.
the effects of the case, and why you chose this case, why it was relevant, what does it show?
Yes, this case, it was really interesting. So it happened in Georgia. The woman, this Canon Yeria, she was with a man. She cheated on her husband, and relatives of her husband saw not the cheating, but they saw them together. And because they saw them together, she received a brutal beating, and not only beating, she was paraded throughout the various villages in Georgia. And her father came. The father came and took her by her hair, then brought her home. And it was a severe case of violence. And when the police came, she asked the police officers, "Why don't you prosecute the offenders?" And the police officer didn't want to translate to the other person who was in charge of prosecuting, whatever. And she was also coerced on killing herself. Her family gave her rifles to kill herself. So it was severe violence there. And eventually she killed herself. But that suicide was not thoroughly examined. She was, her clothes was bloody, and they cannot even know that it was suicide or it was assisted one, but not consensual one, if I may say so. They revoked the CEDAW declaration, the CEDAW here, but the CEDAW can only protect them on the close family relations. And the perpetrators are actually the further family relatives. So I've said everything now. I don't know what I said. But they claim that she was subjected to severe gender-based violence, humiliation, and forcing to commit suicide motivated by so-called honor and discriminatory norms related to women's sexuality. And state authorities knew or should have known that she was at real and immediate risk of serious harm and death, partially given the involvement of police and the village government on the night before her death, and her explicit request for help and protection. And there was visible signs of violence. So state failed to exercise due diligence to protect her from violence, prevent her death, and conduct a proper, thorough, impartial, and gender-sensitive investigation of her death. So what was the findings to see the committee? The committee found that violence against Kano Mirinova, constitutes gender-based violence rooted in discriminatory honor-based norms, and that Georgia failed in its positive obligation to act with due diligence to protect her once authorities were aware of the risk. So I can send you to actually read it, because I think that I only make a thought in your mind. But it's really good case, and it really shows that also this is Georgia. So it is not that far from us. It is quite near. And it is in a rural area, but still. So, yeah. And regarding the Swedish one, I kind of told you what was important there, and that was that this case motivated Swedish police and prosecution to reopen the cases that were because her partner died a couple months before her, and they reopened the case of his death. That's a part. And I had to conclude. Honor-based violence, including honor killings, occur everywhere. Some countries may be prone to it, but this is not an issue that can be left to culture and tradition, and culture, tradition, and religion cannot justify violation of fundamental rights.
Thank you very much. Any questions, comments to what they heard? When we all send each other presentations so that we can read the case. They will all send to me, and I will post So it means if you also want to send the case, please let me know, and then I'll post everything on Google, so you have all presentations.
Yeah, no, they're really interesting and really it was really hard to read just the small parts of it. Really, really, just like, and they let it go. That was the most horrible part. That they let.
What's the reason? Why didn't you initiate the process, and why did you not have adequate sanctions at the end of this case? Although it's brutal one.
Because she brought it to herself. That was the reasoning from the.
Leave the reasoning. What was the reasoning? But what do you think? What's the reason why did we have inaction of state authorities to deal with the case?
Because it's normalized.
To normalize in a way, it also shows that state officials who are here to protect everyone basically have a very similar thoughts on the reason. They, in a way, again, rationalize and agree with the methods. And this is so problematic. Why we said that within the judiciary, we will deal with that next class. We have so many biases in stereotypes itself. And today we speak about the AI and how AI, because within many countries there is the automatization, at least as a first step to reject the cases and also to analyze the case for the judges. And now it's a huge issue, like if it's biased, if the design of these algorithms is biased. But we still have to figure out that we have even persons who should be neutral and objective and are there to basically protect all of us. They're not doing that because they are full of bias and stereotypes. So this is the first step. And then, of course, when we come to AI, it's even sometimes more visible. Any other questions or comments to this very hard topic? I'm sorry as well. These are all hard topics.
The case came into my mind that I don't know if is it from Serbia, but I think it's from the Balkans for sure. That it's a very with older, and I don't know, and I think it was in the news. Grandma had an affair, and then her husband paraded her around the village, punching her. She was going in front of him and he was punching her, but it was a headline, grandma had there. And everybody was justifying what did she expect? Of course, it's, she clearly did her husband, but also that characteristics, why the grandma have an affair. How she allowed to have a love life, sexual life, I think, and that was the argument, and then everybody was all coming, women, men, everybody expected to happen.
It's a very good case because it also shows the intersectionality. It means it's also why she's a social outlet, because for a young woman, we can still expect that she can commit adultery. Someone who is of older age, she should be decent. She's a grandma. She's having a relationship with her grandchildren, and she should teach them about morality and see what she's doing. She dared to do that. So it's really important, and it's a very good example.
Yeah, and I was saying it's a custom in that village. Even though I have never customs, and I'm really that was new to me, but maybe that's just my bubble. But
no, it's not your bubble, because we do not expect in the 21st century to really develop these cases. But it's in all societies. It's just an issue whether it is someone's present or no, and in what specific area. Because in a city, you will not have case, you will have honor killing or parricide in some cases. So it's very interesting just to see all the angles. Dushanka, thank you so much. And we have a third presentation.
Should I just check it?
Another topic which can also lead to very severe circumstances. I'll help you.
Folks online, do you have any question, comment for Dushanka? welcome. Okay.
Thank you, Hushanka, for well done.
Good.
Yes, it was an interesting presentation. Thank you.
Both presentations are really interesting, and thank you so much. I mean, if you have any questions, please just let us know. You can take them. You can unmute yourself. You know that. Okay, so I'll share another presentation, and please let us know that it's visible. Can you see it?
We can see it.
Okay, great. Let me see if it will make scroll. I don't know. It is.
Try to move.
Here.
Ne tu nego na
Da vidimo sa ovim strjelicama da li radi. Samo izvinjavam se sad. Ne, vidite vi. Tamo poslije ću ponovo da isključimo, pa ćemo opet da uključimo. This also happened with my work presentation. I don't know why. No, it's happening also sometimes, I mean, to me as well. I don't know why. Šta se dešava? Maybe. Ja vidim da li ću ponovo da vidimo prvo da li je ona koju smo otvorili, da li je dobra. Ne, on se sam sebi ne otvara. Ne znam šta je. Iz nekog razloga neće. Da vidim. Ne znam se sad skroz sada probamo da otvorim PowerPoint, pa možda tu da ga sam probamo. Makar PowerPoint. Ja nemate vi neku vašu da ne možete slobodno. Sorry guys, online. Ok. Probajte se ponovo. Tak, so if not, what can we do? Okay. Recovery document. Close recovery document. Help. Oh, something happened. But never mind. We'll go čitam samo vremena. Yeah. Okay. Isključite. And this close. And this. Okay. Yeah. Sad tamo idemo na share. Da šerujemo ništa. Trebalo bi da sad okay. Can you guys see the presentation? I don't know. Guys, online.
We can now. Yes, it was loading.
So, the topic that I will cover today, just to see how I go with the slides. Oh, here we are. My topic today is abortion bans, and I focused a bit more on a legal part of the team, so it won't be maybe as interesting, but I hope that we will learn something together. I give here a brief overview of what we're going to talk. So first, some definitions to understand all the terms better, and later case law and legal framework. To see this perspective from the gender base and what are the main cross sections of abortion bans and gender issues, some case law and conclusions. So in order to start, what are abortion bans? Abortion bans are legal rules that are restricting or prohibiting abortion. That's the simplest way to explain it. It's prohibiting on a scale on prohibition or restrictions. We have total prohibition, which is rare nowadays, but bans are also limiting the right to abortion or forcing it to be only on the certain grounds that the state allows. You will see later some percentages. What are the allowed basis for when the abortion is legally permitted. And it is often enforced, of course, through criminal law. That is why, unlike femicide, here we are talking about decriminalization. We want to take the abortion out of the criminal law in terms of some punishments that are imposed on the procedure itself and the individuals who are participating in it, healthcare workers, and of course, pregnant individuals who are seeking it. And of course, what are the roots of this issue? Religion, moral, and state control, which is the reason why we are talking about today. The presentation will be uploaded on Moodle. Here is some development through history. I will not go in detail through that. I will just say that today's developed countries until the 20th century had strict prohibitions on abortion. UK and its colonies, the rest of the Europe, and of course Islamic countries, which is an issue today. But I will mark one, the one that started all, the case and the women who started this progressive abortion reform. It's a feminist from Soviet Union from 1920. Alexandra Kollontai, I hope I'm pronouncing it correctly, but that's the case that started this progressive legal reform for abortion. And in order to understand the terms, I made a distinction between legalization and decriminalization. We have a legalization of abortion. It is within the legal systems, within the legal norms. We can find it in laws. And as you see, here are the numbers on worldwide countries who allow abortion on which grounds. And a large number of countries are permitting abortion when it's the case of life-threatening situation towards women. But only 27% allows abortion on the request of women. Only 27. I can say that our legislation, now we have a special law, lex specialis, in this field on termination of pregnancy. And we are in that 27% because according to our legislation, the woman can ask for abortion, and abortion is done only by the request and the consent of women until the 10th week of pregnancy. So that is a legalization. On the other hand, we have decriminalization, which means this is the global trend now, the trend that World Health Organization is attributing to, and that is to remove punishments from abortion. The only country in the world that is completely decriminalized abortion is Canada, the only one, since 1988. And there are, of course, many reasons why decriminalization is important. I will not go into detail into that. We will go into the...
Some specific, because it's very important. Decriminalization. Maybe just to go through the arguments why decriminalization, as you put.
Why does it matter? Well, decriminalization. First of all, what the results show in the facts from the research that I took, the more prohibitions are imposed, the higher the deaths and complications are. So it's a paradox. The states are constantly trying to say, with these prohibitions, we will protect women, we will protect fetal life, we will protect. Usually it's within the protection we try to protect, but they're unfortunately protecting no one because people, of course, when something is prohibited, such as this case, which is related to your own body and health, you will try to find other ways to, and unfortunately, especially in the rural areas, here is the intersectionality comes in the game, because women from rural areas, they will not have the enough resources to even go to a private clinic or to any doctor. And they will try to find alternative ways to help themselves in this situation. And as I said, the facts are simple. The more prohibitions are imposed, the more deaths and complications from the procedures occur.
In other words, the decriminalization leads to unsafe abortion.
That's for sure.
Result,
yes.
serious injuries.
World Health Organization issued guidelines on how the abortion is a safe procedure, and it shouldn't be an issue anymore. If it's with all the medical improvement that we have, it really isn't an issue if it's done according to these guidelines. But of course, people are still stigmatizing it and telling it, oh, the women are hurt, the women are killed during these procedures. If not done within the legal framework that we have, which should allow it and have no stigma around it. So protecting people's health and lives, as I said, reducing stigma, even when it is allowed, like in Serbia, usually you will face social, family, work stigma, any type of stigma, and kind of judgment on women and, of course, other pregnant people who want to do an abortion. It's always followed with society's judgment, and it's very hard to make a decision. I've been through personal cases with close people who went through this. It's not only the question of legalization or decriminalization. It's a really emotional, hard subject, which is completely overlooked within all of this abortion bans topic. It's completely overlooked, and it's very hard for people to go through it, and we are leaving the mental state usually behind.
But it's very interesting, just to interrupt here. You have some researchers now showing that women will not speak about abortion even in a very, let's say, near surrounding among friends. But it's even it's the same with situations when someone lost the baby. It is exactly the same. So it's so stigmatized and also emotional in a way.
It's always a shame.
That story is not shared with anyone, even in a surrounding when you feel safe.
Safe, of course. I've seen that many times in real life, where there is a certain shame that you have through society. Not you know that your friends and family won't judge you, but you feel this shame, and it's awful. So these are only some key. Of course, there is a lot more that we can talk about, but we can go to international framework. I wanted to focus.
Because you just keep it. I think it is very important
Yes.
to put here. There is no explicit right to abortion in international.
Yes, that's what surprised me the most while I was doing research. I told the girls before the class, I was really surprised that there is no single one clear provision on rights to abortion. It is not, there is no binding treaty, nothing. International community protects right to abortion through interpreting other established human rights. So rights to health, right to life, rights to privacy and bodily autonomy, rights to be free from cruel and inhumane. So all of these human rights help to interpret the right to abortion. But there is no one clear provision.
What's the reason for that? It was not unexpected. It's like expected thing because you have different practices of different states. So you cannot have one unique provision saying the right to abortion is protected, or there is the right to abortion, because then you will have so many exceptions. And it's not possible. But this is in accordance with other well-established saying human rights and freedoms, depending on the fact of the case. But it usually goes with sexual and reproductive health rights, reproductive health.
We have, that is on international level. On regional level, we have one very important, I will talk about it later, in Africa, which was also surprising to me, that is a binding treaty with explicit rights to abortion in the certain circumstances. So we will go through this. I focus here on the main ones that explicitly says something about abortion. So we have International Covenant on Economic, Social, and Cultural Rights that says the rights to reproductive health care and interpreted in a way that it must be accessible, acceptable, and of good quality for everyone, which also includes an access to safe abortion services, especially when there is a denial of some physical or mental health. This is Article 12, General Comment 22. It was not
I didn't put it here, but afterwards I remembered. So the other one is Convention Against Torture and other cruel, inhumane, or degrading treatment or punishment, which says that it issues a lot of findings that state that, of course, forcing a person to continue a pregnancy in cases such as rape, fatal fetal abnormalities is a form of inhumane and degrading treatment. We have General Comment 36 on International Covenant on Civil and Political Rights with the right to life that explicitly says that states can regulate abortion, but in such a way that it cannot jeopardize the life of the pregnant person or subject them to the physical or mental suffering. And of course, CEDAW, elimination of all forms of discrimination against women, that says that this is also a question of gender-based discrimination, which really is, because as we said, imposing punishments put women at higher risk for life, for their body, and it's a form of gender-based discrimination. 100% in my opinion. We have General Recommendation 24 that emphasize that states must, this is for me very important, because one thing says usually in law, we have the thing that's written on the paper and what's in real life, and what kind of obstacles women have to go through in order to access the service that was provided to them.
This is very important to say in answer, because it's not enough only to read the law and to see in this state abortion is allowed.
Yeah.
We need to really see what are the barriers. And for example, in our region, maybe just to complement what Ksenia said, ex-Yugoslavia was the first country in the world to, in a way, recognize the right to abortion, not explicitly. Implicitly, it was in a constitution from 1974. And in that regard, this is the country, the countries from ex-Yugoslavia which have a liberal laws. After the separation, dissolution of the state, in some republics, Serbia is a good example of this. For example, in Montenegro, what happened is, I don't know if you know that in politics, there is some kind of statue in the name of all female actresses, which couldn't preserve because from the moment when it was easy to identify the sex of the fetus. And in order to have more sons, it's also a traditional thing. Many female child, they use abortion. For example, that's one practice in the region. In North Macedonia, I think until 2019 or 20, they had a practice that if you want to do the abortion, you need to go to the medical check. But the medical check was not like the ordinary medical check. It was a medical check where the doctor will give you and it was compulsory, to listen to the heartbeats of the fetus, which was a way to again impose to you more hardship with this decision. In Croatia, that's also interesting. We are facing with something which is called conscientious objection. Mm-hmm. Do you know what it is? Yeah. So it means that the doctors are rejecting on the grounds of religion to do the abortion. It is almost impossible to do the abortion, but the law says it's allowed.
It's allowed.
So this is why the recommendation number 24
is very
important.
You will see in cases as well, in case law that we will cover, especially in Europe. The trend in Europe is to go towards state's obligation to really exercise what is permitted or what is allowed, or to really make it possible in real life, because it's usually not, especially in abortion cases. So that is why this general recommendation is very important. We also, I already mentioned, World Health Organization and their guidelines. We have, as I mentioned, their elements of the safe procedure of abortion, which when followed, there shouldn't be any problems. But also, other than that, they advise strong decriminalization of abortion and emphasize that criminal laws do not reduce, as we said, abortion rates, but push people toward unsafe procedures. And one specific case in regional law, it's Maputo Protocol. I hope I'm pronouncing it correctly, but it's a protocol to the African Charter on Human and People's Rights and the Rights of Women in Africa, which is the only binding treaty that explicitly guarantees the abortion access in 6, I believe, grounds, but binding to all the states and in the treaty. And it's very progressive for its region, which is why I incorporated as well. And it's once you Google it, it's the first thing that popped in my research was this protocol. So now a bit of a gender side of this story, and why is it a gender issue? If we see the abortion bans from the perspective of gender, we can analyze these challenges. First, the disproportional impact, of course. In everyday life conversations, usually men will come to me and say, well, I also have a participation in this. I also, this is a discrimination against me because I provided the material. I was the active participant. I'm also discriminated if I'm, so that's usually the kind of statement that I hear. And then I talk a little bit about how stigmatized and how dangerous the prohibitions and procedures are towards women, and then they come down a little bit. So it really disproportionately impacts. I mean, women's bodies are usually, due to these prohibitions and bans, then subjected to harmful procedures in order to help and save themselves. And it's really disturbing. Also, gender-based violence, as I said, it's through recommendations and interpretations of human rights. It is a form of gender-based violence through pushing women and people who are capable of being pregnant towards unhealthy procedures, and that's the form of gender and intersectional inequalities. This is what I think is the most important challenge, because we cannot compare abortion access of women in Sweden and some migrant women and minor people who are coming from a low-income families, rural. So it's completely different story, and we really should not forget the intersectionality approach within these abortion cases. You will also see it from the case law, how much it affects the women within this. Okay, and the state regulation and bodily autonomy. I think it's the most media covered challenge. It's the my body, my state, my choice that we see on the protest. And it's really a question who can decide what will you do when you're pregnant. Is it a state's question, or is it a question of a person whose body has to suffer through either pregnancy or terminating the pregnancy? And both are difficult decisions. So it's ongoing debate even today. We will go through case now. I decided to cover cases from U.S. Supreme Court and EU to show the opposite trends globally. So U.S. is going backwards, roll back in the U.S., and that's what sparked all of these protests that we see on social media. And on the other hand, EU is kind of having a step forward, and the most cases that I found are focusing on the broader access to a right to abortion and kind of obliging states to make it more accessible to women, and how to make it more accessible. You will see later. But the U.S. Supreme Court, this is what first goes in when you Google the case law for abortion ban, this is what first pops up. It's three famous cases which follow chronology and kind of degradation of the whole U.S. system on abortion bans. So first we have an old case from 1973, which established the good grounds in U.S. laws permitting or allowing the abortion as a right on a federal level. So all states for more than 50 years, based on this groundbreaking case, Roe versus Wade, it was a woman named Joe, I believe, Jane Roe. She challenged a Texas law that prohibited abortion in all cases except when it's necessary to save a mother's life. And Jane Roe, that's why it's called Roe, challenged this, and the court ruled that 14th Amendment to the U.S. Constitution encompasses also a woman's decision to terminate a pregnancy. And it was a groundbreaking case, and ever since then, in the U.S., on a fundamental level, it was considered as a right. Then we have a second case, which kind of started to shift the focus towards worse direction, but it still haven't overruled the first case. It's a Planned Parenthood versus Casey. This is related to the state of Pennsylvania, that is introduced a number of restrictions, and the clinics were the one who challenged this. The court haven't overruled the right to abortion, but said states can impose restrictions, but these restrictions shouldn't be substantial ones and shouldn't impose like an undue burden. That's how they formulated it. So you can impose restrictions, but it shouldn't be like too much for a woman. So it already gave a bit of a direction to the right wing. And then 2022, the case that broke the media, it is Dobbs versus Jenkins Women's Health Organization, where Mississippi passed a law that bans most abortions after 15 weeks of pregnancy, which is in direct violation with previously established case law. And have in mind, in the U.S., case law is much more important than in EU. Case law is what creates the legal systems, much more likely than in EU. So in this case, surprisingly, Supreme Court said, the U.S. Constitution does not contain a right to abortion, and it is an issue that should be resolved within states, not on a federational level. And then the chaos started to occur. All of the states did whatever they want. Someone posted restrictions, someone didn't, and then we are left with complete legal uncertainty of women living there. They don't know which stage allows what, where to go, what to do. So that's the, I think, main source of all of these protests that we see nowadays, and rightfully so. So that's the kind of chronology in the US. And in EU, it's not as dramatic. But I also found three most interesting cases before the European Court of Human Rights. The first one is related to Ireland, and it shows us the intersectionality within this. Traveled from Ireland her eligible for abortion procedure because she was sick of cancer, but she could not get a clear medical or legal opinion so that she could have a safe procedure. And the court ruled that Ireland failed to provide an effective procedure to determine if she's qualified for a legal abortion or not, and she was then forced to move to UK to have a safe procedure. So that is, again, we are in the EU cases, you will see we are focusing more on how to make a better access to abortion than this political right left wing as in the USA. The second case is Tiziak, I hope I'm pronouncing correct, versus Poland from 2007. In this case, we have Alicia who suffered severe short-sightedness. And she feared this was her third pregnancy, and she feared that it would leave her completely blind.
She feared, but there were medical...
yeah, she feared. And then her fears were confirmed by the doctors, and the medical staff said, yes, this pregnancy will definitely leave fatal consequences. The result was that she was declared as, I believe, disabled due to this pregnancy. And after her delivery, she basically left blind. And the court found the violation of right to private life, and Poland failed to provide legal and legal framework to resolve disagreements between her and the doctors regarding the eligibility for a legal abortion again. So it was again a procedural thing and hard access of your rights within the health legal system. And the last, which is the hardest one for me, it's PNC versus Poland, mother and daughter of 14 years old who became pregnant as a result of rape. And she faced systematic harassment, pro-life activist interference in her case, hospital refusals. She and her mother were prevented from obtaining the abortion procedure, which is, of course, the courts found, thankfully, that it found multiple violation of all basically human rights in this case. So this case confirmed that it's also an intersection question here. So that's the case.
Just to say, it's not EU cases, there are cases from Council of Europe.
Council of Europe, yes. Yes. And the conclusions, I think we already covered them through the whole presentation, but gender and abortion are overlapped in various different fields. As you can see, it is a question of equality and autonomy of one's body, of course, discrimination. There's an economic aspect, stereotypes, health inequalities, intersectionality, as we've seen through case law, gender diversity, gender-based violence. So I believe we covered them through presentation, how we can intersect these two.
And what you said in the good in representation democracy, this reproductive rights erosion, which could signal democratic backsliding. And this is exactly the case. So what we can expect more and more states introducing more restrictive bans.
Unfortunately, yes, that's a global trend now, unfortunately.
Any question? Any comments? Nothing. It's in that case,
Thank you.
Like all our presentations, an excellent way to go through the first of all notion, then trends, legal background, and also some cases. Thank you for that. Anyone online, do you want to ask anything or comment? Anything? Okay, if not, any other intervention? Anything that you wanted to say in general concerning the right to life? We also had, and what I put is enforced disappearance. This is, but this topic is, let's say, the lightest in terms of gender perspective, as there are not still so many researches on the issue itself. Enforced disappearance is also part of a special convention, which was introduced on a UN level, which defines what enforced disappearance means and what is the obligation on the part of the states. So there are also some general comments which are interesting for reading. Enforced disappearance means that we don't know anything about the whereabouts of a person. And the only thing that we know is that the person was put in the hands of the state. And there is no information when the person is held, if the person was killed, if the person was buried. So no information on that. And it's a really huge suffering, psychological suffering that, first of all, family members and close persons are attached to. The only thing now that there is some kind of trend that we are talking about on a global level, and it's interesting for you if you want to read more about this case, is that basically we have a huge again, attack on women human rights defenders in many countries. And now we have more and more cases
not only, for example, the enforced disappearance is related to Latin America, where it started and when it was really widespread and systematic. But nowadays, we have in all countries that women human rights defenders are facing also with enforced disappearance, and especially if you have really activists in this backsliding that we discussed, which dare to speak in public and to defend rights of women and girls. There is no country in which we don't have at least one case of a disappearance today, or at least the one that is maybe considered to be related to the rights defenders who are in much more in harder situation than everyone else. But it also shows this democratic element that we are facing today. With that, I'll thank you for all your beautiful presentations today. I will kindly ask you to send it to me as soon as possible, that I can also post it on a Moodle platform. And of course, if you have any information you want to write a seminar paper or even a master thesis on one of these topics, I think that they're all excellent for further research on the matter. Thank you all. Thank you,
Professor, and thank you to my colleagues who did the presentations. They were wonderful. I enjoyed them a lot.
Great. So you got applauses from
We learn a lot from this.
Thank you. Thank you so much.
Thank you. Enjoy it. Have a good night.
Thank you so much, and see you on Friday. And don't forget that tomorrow you don't have classes, and that Professor Tanasi Marinkovic will send you information on when you will have the class for feminist judgments. Okay.
Okay.
Enjoy the rest of the night.
You too, Professor.